Greetings and welcome to Calabash Community Talk with me, Ramotse Jonathan. Today, Renale Kwazi Dlamini, like we always do on Thursdays, we're talking to her about the issues HR and labor. She's educating us. I told you by the time we leave this show with Kwazi, we can go and ask for the certificate from whatever university or Moyona because we would have known about the issues labor. Today, we're talking about disciplinary inquiries. We want to know, what do I do to go to a disciplinary inquiry, and who are those people who need to be in that disciplinary inquiry? We not want to know so that when you go in there, you find gore ga ba go gatelle, and when you don't, you go inside there with the full information. Ozgwazi, welcome to the show again, once again.
Thank you, Jonathan. Thank you to the viewers as well.
Before we continue, let me remind our viewers and listeners where you can still subscribe to this show and become member ya community e re batlang go e builder, give you information that will be building you. Subscribe to the channel ya rona, and also if you want us to ask something, send us an email, go podcast@calabashcommunity.co.za, podcast@calabash communitynetwork.co.za, or you can still send us that WhatsApp 0815813936, 0815813936. That's where you can speak to us with wasting any time. Ozgwazi, disciplinary inquiries, re bua kae?
So, with disciplinary inquiries, we are actually looking at what happens, Jonathan, when one is taken to a disciplinary inquiry, or sometimes it's referred to as a hearing. So, that's what we're discussing today.
So I was given a letter to say you are suspended, and after suspension, I was given a letter to attend the hearing. What must I look for when I go into those hearings?
So, yes, thank you for that question, Jonathan. So, firstly, I think just a reminder, and you will find these things are linked in our in the the podcasts that we do. So, when we talk about a disciplinary inquiry takes place because an employee has been found to have committed a misconduct. And the employer has investigated and found that indeed this employee has committed this offense. So what then the employer will do, they will charge the employee. And those charges are placed on a document that is called a notice to attend a disciplinary inquiry. The notice to attend a disciplinary inquiry will have the following as included in that document. It will be the name, the full names of the employee, the date of the inquiry. So the employee who has been charged needs to know when the inquiry will be sitting. And they need to know where. So it must also state the venue of where the inquiry will be stated, so that that particular employee can then know when that inquiry is actually going to take place. Further to that, very crucial information that must be there is the actual charge. So when you charge an employee, you must be simple, you must be specific, so that the employee understands how they can prepare themselves against those charges. Remember, when you are charging an employee that is going to a disciplinary inquiry, they are going to defend themselves in that inquiry. So that employee needs to know what that charge is. I'm going to make an example. If my employer then says on Monday, I reported for duty under the influence of alcohol. We need to state when. When did I test positive for alcohol? What did the positive test indeed indicate? What proof is there that indeed I had tested positive? So the charge is very important. It must be specific. It must be clear enough for the employee to understand, so that they can prepare sufficiently for their defense. Furthermore, that notice the notice to attend a disciplinary inquiry must also include the rights of the employee, the right to an interpreter, for instance. So umuntu umethi, Jonathan, mina angisizwa kahle isingisi, ngicela ukukhuluma ngesiZulu noma ngicela ukukhuluma ngeSetswana ke batla bua, because that's the language I'm comfortable in. It's their right to do so. So what the company then has to do, they have to make sure that where an employee has requested for an interpreter, they provide one. It is important because it's a procedural issue, Jonathan, that we cannot continue when an employee has requested for an interpreter and the interpreter is not there in the inquiry. We can't proceed. Secondly, an employee has a right to representation, but that is limited to a fellow worker or fellow employee or a shop steward. But if the employee who is accused or taken to a disciplinary inquiry is a shop steward, then they can be represented by a trade union official in the inquiry. But attorneys don't represent employees during internal disciplinary inquiries. Those rights will also include the right to bring in witnesses. So while the company has a right to bring its own witnesses, employees also have to can also bring in their witnesses and also submit their own evidence to defend themselves against those charges. And they have the right, to confirm that they've received this notice to attend a disciplinary inquiry, which is why they also get to sign for it to show that I have received this notice to attend a disciplinary inquiry. And then this notice, Jonathan, what's also very important that it must be issued to the employee at least minimum 48 hours prior to the disciplinary inquiry. So you can't give me a notice today and say the inquiry is sitting tomorrow. It is a procedural flaw.
Before I go to other questions, let me go to the immediate one. Why is it important that the person must get the notification 8 hours, at least 48 hours before the inquiry?
It is required by law that an employee must be given sufficient time to prepare for the case. So that is important. That's the importance, yes.
We speak about the rights of the employee, and one of those is the interpreter, that there must be an interpreter who's going to come and then interpret and help assist in the flow of communication there. Where must the interpreter come from? Internally, or is anyone who can clearly interpret, or to bring the person from outside?
Normally, the company will just bring someone who is within the company. So it's the company's responsibility to ensure that there is an interpreter. If the company doesn't have someone internally who can interpret, then they then have to source externally for someone to
And
provide for those
cost.
services. Yes.
Okay.
Yes, of course. Yes,
Let's talk
including
about the
those
witnesses,
costs.
because in most cases, when people go into inquiries, they go there without witnesses, not because witnesses are not there, but because people are afraid of becoming witness to against their employers. So how do we work around this thing? Because in most cases, people lose cases not because witnesses are not there, or there's no someone who can give evidence on their behalf.
So that is an issue clearly in the company because no employer should ever have to victimize or discipline an employee who wants to witness on behalf of another employee truthfully. So if I know what transpired, I know Kwazi wasn't there, I know Kwazi didn't test positive, and I saw had a negative test, and I can attest to that, I should be able to do that. It would be very unfair if it is found that the employer disciplines employees for being witnesses. There shouldn't be anything like that. It's very unfair. So we discourage such interactions between employers and employees so that employees feel comfortable in the organization to say, I've got a matter, I can get so and so to be my witness, and that witness will not be victimized. It would be wrong for any employee to be victimized when they are going there to be witnesses. Witnessing, of course, requires that one is truthful in their testimony. That must also be emphasized.
So on a day of the hearing, I go to hearing. What should I expect? Who should be in that room where the hearing will be taking place?
Great question, Jonathan. So in that room, there will be a chairperson which is the independent person who will be presiding over the matter. So then there will be the complainant. A complainant is the one who is acting on behalf of the employer, who is representing the employer in the case. And then it would be the employee who is there as well. And that employee, of course, is there to represent themselves. So sometimes employees elect to represent themselves. Sometimes they elect to have a representative in. So an employee's representative can also be present. If the employee has requested for an interpreter can also be present in the inquiry. What I must also add to that is that in the event that either parties, and when I say other parties, I'm referring to the employer and the employee, if they both have witnesses in the inquiry, they will only come in at the time when they have to be called in as witnesses. So that's how it happens, yes.
So the company representative is not allowed unless it's someone who's going to be leading the case on behalf of the company. So let's say the company decided the supervisor will lead this on behalf of the company, and then HR manager said, I want to come in just to observe the procedures.
Yes.
Is that allowed?
Yes, HR has to be present. Actually, they are one of the people that are very important in those proceedings because they have to ensure that the process is fair in the manner in which the chairperson conducts themselves. So they need to definitely be there to oversee the process.
You know, there are cases that I want to mention, but I'm just gonna make an example. You go into an hearing and you can see already that you're not gonna, not because there is no evidence, but you know that this is just hearing. This hearing was just organized for just process to go on. You go in there as an employee. Do you have a right to say, I don't want to continue with this? Or you say, let me continue with it. I will then challenge it at the next step, which then becomes the CCMA or the labor court or bargaining council
That is the
in that
perfect.
case. Yeah.
That is the way to go. A lot of the times, I must be honest, Jonathan Uguti, I find that abasebenzi they are sometimes of view Uguti. I know the outcome lie Uguti ngiphume already kungakaqalwa nokuqalwa, but that's not how it works, or that's not how it should work. A disciplinary inquiry is supposed to be fair, and the chairperson is supposed to ensure that there is fairness. Because in the event that there is any procedural defect that is found in that process, it can be challenged at the CCMA. And if indeed that commissioner who hears that matter finds that the chairperson did some things that are procedurally flawed, an employee can actually win that case. So it has consequences if there's any element of unfairness, either substantively in terms of the reason why the employee was charged, the substance, and procedurally if there was any procedural defect in the actual inquiry. So remember, even if the employee is going to challenge this at the CCMA, the employee has to prove what the chairperson didn't do. So to just say to the CCMA, I just saw them and I knew that outcome say velile vele bafuna ukungixosha. It's not sufficient. You have to prove the unfairness or the alleged unfairness that the employee would think they have experienced. Yeah.
What are the duties of the chairperson in the hearing?
So, good question, Jonathan. The duties of the chairperson in an inquiry, one, is to explain firstly the process because they are the ones who are presiding over the matter. A chairperson is the one who will be listening to evidence from both parties and then make a finding based on the evidence that was led, the testimony. And remember, Jonathan, a disciplinary inquiry is not treated like a criminal case. So, with a criminal case, one has to prove beyond reasonable doubt that this person actually committed this crime. But it's different when it comes to labor cases. We deal with labor cases based on a balance of probabilities. Which version is likely to be true? So we are not there to prove beyond reasonable doubt, but we are saying this is the version that I'm giving, and the chairperson has to listen to both versions and make a finding based on that. So the chairperson, firstly, in the inquiry, will explain the process, because sometimes abasebenzi, they are not familiar with the process. Khona abasebenzi abangakaze ever benze or noma baphula umthetho wasemsebenzini, so they wouldn't know. So kubalulekile ukuthi uchairperson mayefika explain kahle the process enziwayo kwi-disciplinary inquiry, and then achaze ukuthi kuzokwenziwani, kuzoqala bani ukupresenta, which would be the company, and once the company has closed its case, bese umsebenzi or the accused employee naye akwazi ukuchaza their side of the story. And then based on that, both parties, of course, would have had an opportunity to lead evidence, but yena umsebenzi wakhe is to make sure that there is order in the inquiry, kungabi nokudelelana, being disrespectful and all of that. So it has to be conducted orderly, and they are there to ensure that it is fair and that it is orderly, and respect as well is maintained throughout the process.
What skills should the chairperson have, the chairperson of the hearing have?
Okay, so different chairpersons have different skills. But what is important is that they know how to chair. So some chairpersons are actually attorneys. Sometimes, other attorneys. Some chairpersons abanye, they are commissioners mhlawumbe from from the CCMAs or who used to work there. Sometimes a chairperson can be somebody wasemsebenzini who is asked to listen to both parties. Could be a manager from a different department or from a different branch. Different companies do it differently. So abanye, they prefer to outsource that service to somebody. Abanye, they prefer to do it internally. But all we are saying, or all we are encouraging, is that chairpersons must conduct disciplinary inquiries fairly. That's important.
The initiator, what are those duties that the initiator? In this case, I think the initiator will then be the company.
Yes. So sometimes we refer to either an employer's representative, sometimes we say they are a complainant or an initiator, but they are representing the company. So the representative of the company is there to ensure that they plead the employer's case. So it's their job to prove the charges that have been leveled against the employee. So if you are saying that I reported for duty under the influence of alcohol and the positive test read 0.60%, then you must prove that. So you show that I was tested on this day. You've got a document that shows that it was 60% and all of that. And you present your case to the chairperson to show that your version is true, because the chairperson has to consider the employer's version. And then what the employer, the initiator or the complainant can do as well, is to ensure that that they call their own witnesses if they have any. If they have a footage that they need to play, they can play that footage to show what the employee did. So it all forms part of presenting the employer's case by presenting also that evidence that prove that the employee who has been alleged to have committed an offense actually committed that offense. So that's the duty of the employer's representative.
And then the accused?
The accused is also there to do the same. The accused has a right to, defend themselves. They can either plead guilty to the charge, meaning they are saying, I admit to have done what the employer is saying I have done, or they can say, no, I'm not guilty, and I will prove that I'm not guilty. I saw that the employer's representative, for instance, showed a footage. That's not me in the footage. Or the employer says I was at work that day. I actually was not at work. So the employee is there to defend themselves the best way they know how. And if they also have witnesses to bring in, they bring in their witnesses to come in and testify and corroborate their version as well, that indeed on this day I was not there, or indeed it's not me on the footage. So again, the employer. So I must also emphasize this: when both parties bring in witnesses, both parties also have an opportunity in the inquiry to cross-examine the other party's witnesses. So that's important. And employees and employers' representatives need to ensure that they prepare themselves sufficiently when they present their versions to the chairperson.
No, I'm thinking of one of the answers that you gave us, or explanation that you've made, that in a hearing is not like in a criminal proceeding where you have to prove beyond reasonable doubt. It works on probabilities. But you have this chairperson who's been paid by the company, whose income comes from the company, who at any time can choose not to listen to that. And I'm saying this based on my personal experience. Choose not to. Let me just give you an example so that you know where I'm going. Here's Jonathan, who's working in a company, and while you are in the company, you decide there is animosity between you and your superiors. You decide, okay, fine, let me take a junior so that we have peace. Let me take a junior position, and then I work on junior position for 2 to 3 weeks, and then next time you get a hearing that Osgwazi, who was your client in your previous position, called you and you failed to give that information. And remember, Kwazi called you on a weekend. And so it's things like that. You get a hearing and then they say, okay, fine, that is final written warning. You say to them, I'm going to challenge this. I'm going to CCMA, and then they charge you with something else. So during that time, you can see your man, this person is going to fine against me in this, and not because the chairperson thinks you're guilty, but because that's where the money is. And you can hear during recess, when you are in recess of that hearing, the chairperson is telling you, no, you're presenting your case well, you must be a lawyer, you know how to put your story. But yeah, it's things like that. Then come the final hearing, he's not there. And the company comes with that and say you are dismissed. So how do you work against, or do you still say, okay, fine, I'll allow the process to go on and then go to the CCMA?
So if I'm hearing you correctly, the chairperson is not there and the
Mhm.
company just gives you a letter and says you are dismissed. Is that what
You
you're
are this.
saying?
Yes, these are the findings that comes from the chairperson. Mm.
No, we can't make a finding where there was no actual disciplinary inquiry. That is
Mhm,
procedurally flawed.
mhm.
So
No, no, the
the
inquiry
company,
was
so
there, but just for for procedure. So they tick the box to say, they say this will just will prove that we had a hearing.
So,
Mm,
so remember,
mm,
the chairperson has to bring its notes.
mhm,
So chairpersons take notes,
mhm,
and in their notes they state what the employer said in the
mm,
inquiry. They also have to state what Jonathan said
mhm,
in the inquiry, and
mhm,
they have to give
mm,
reasons for any
mm,
finding. So if the chairperson says, I find Jonathan
mm,
guilty, they have to state
mm.
reasons why they find Jonathan
Guilty, yeah.
guilty.
Mm,
And
mm,
yes, so they cannot just think of nothing
mm,
or say nothing as a reason.
mm,
It would be unfair.
mm,
They have to have considered what you said,
mm,
because that document, that outcome document that will be issued to the employee after the inquiry has been concluded, whatever the outcome, whether the employee is found not guilty, the chairperson will state reasons to say, I didn't find Jonathan guilty because the company failed to prove this, that, and that, and that.
mhm,
Or I did find Jonathan guilty of this offense, and this is what I assessed. Of course, this is what I got from the company, this is what I got from Jonathan, and I'm finding Jonathan guilty because the company has proven, based on balance of probabilities, that Jonathan indeed
mm,
committed this offense. And from there, the chairperson will then find an appropriate sanction after considering, of course, what is called mitigating factors and aggravating
mhm,
factors. So, aggravating factors are the factors that are stated by the employer to the chairperson of the inquiry to say, Jonathan has committed this offense. Jonathan is, for instance, they look at the disciplinary record. Does Jonathan have a clean disciplinary record? The level of seniority in the organization, the number of years that the employee has been with the company, how serious the offense is viewed by the company, what the disciplinary code states as a sanction for the kind of offense that Jonathan has committed. And then once they are done with it, then they come to Jonathan. They say, Jonathan, tell me, in the event that I find you guilty, tell me, what do you want me to consider as mitigating factors? And you say, I've been with the company for 15 years. I had a clean disciplinary record. This is the first time that I've been, charged ever. I've never received a warning ever in my life. I have a family. I have children. I have dependents and all of that. So they consider your personal circumstances as well. And it's important that both mitigating factors and aggravating factors are considered when making a sanction or recommending an appropriate sanction that must be issued to the employee. So, for instance, I'm going to make an example. Let's say a chairperson says, I find Jonathan guilty, but I'll give Jonathan a final written warning instead of dismissal because I found that, he admitted, let's say Jonathan pleaded guilty in the inquiry. I found that Jonathan was remorseful. He pleaded guilty, and I considered his circumstances as well. And I find that an appropriate sanction would be a final written warning, even though the disciplinary code says for the offense that Jonathan has committed, it warrants a dismissal. So they will consider that, and they will also always consider the nature of the offense. So I'm going to make an example. If, for instance, I reported for duty under the influence of alcohol, and the company says we can give him, the trust is broken, but it can be repaired, and the chairperson also considers your mitigating factors, and they say, yeah, no, Jonathan, I can give you a final written warning and not dismiss you, even though the disciplinary code says I must dismiss you for committing this offense. But then you find that here's Sbusiso. Sbusiso is charged for theft. Sbusiso also pleads guilty in the inquiry, is being remorseful.
It's broken.
But then the company says the trust relationship is broken irreparably because of the nature of the offense. I mean, theft is different. There's no amount of personal circumstances that can assist you. At that point, you are saying, I've got children, I'm a breadwinner, I've been with the company for 20 years, but yet I've stolen. You know what I mean? So you find that in that case, the chairperson says, no, this offense is much more serious and the trust has been irreparably broken. Therefore, I'm finding that the appropriate sanction is indeed a dismissal. So it must be noted as well that each case is always dealt with on its
To
own
understand that.
merits. So we need to understand that.
We talked about the aggravating factors as well as mitigating factors. Then the chairperson take all this, is going to sit down and consider them. He comes back. How do I then find the outcomes?
So what happens is the chairperson will give us a document with the minutes of the hearing, and will state everything that the chairperson has considered from the employer's version and the employee's version, and therefore will give us an analysis of evidence. After the analysis of evidence, they will then give us a finding. That finding will either be guilty or not guilty. If it's not guilty, then the chairperson does not need to consider mitigating factors and aggravating factors because it doesn't apply. The employee is not guilty. But in the event that the employee is found guilty, then the chairperson has to then, after looking at it, of course, they've already looked at evidence, look at the aggravating factors. How serious is this offense and how the company views it? And of course, consider the mitigating factors of the employee and then give the appropriate sanction after considering those factors, yes.
So,
So everything has to be documented.
as we are about to close it, what's the weight? This results or from the outcome, the weight of the outcome when you go to appeal this thing.
So, for instance, if one has been dismissed, so you then and you want to look at an appeal. So it must also be noted, Jonathan, that not all companies have the appeal process. With other companies, if you've been dismissed, you just have to refer your matter to the CCMA and state there that you feel that you've been unfairly dismissed, and you will state reasons, whether it's substantively unfair or procedurally unfair. Substantively unfair meaning the reason why you were dismissed is not fair. And then you look at the procedure, meaning you look at the procedural aspects that were not followed, that were unfair. For instance, if I was not given an opportunity to state my case, or if I was not given an interpreter and I didn't understand what was happening in the proceedings, or maybe I wasn't allowed to bring in witnesses, and I would have to state that when I refer my matter. But some companies then allow for an appeal to take place. And an employee can appeal based on three grounds: if the employee has new evidence, if the employee feels that there was a procedural defect that I've just outlined, or if the employee feels that the sanction that was imposed was too harsh. So those are the three grounds that an employee can lodge an appeal based on, if they find that the outcome and the sanction that was given was unfair. But I must reiterate, not all companies allow for this
Also, we've
process.
come to an end of the show. Thank you very much. We will be continuing again with this discussion, Sarona. Is there anything that I've left behind? We did not touch on.
No, I think you've covered everything. But what I just want us, the one thing that I just want to emphasize, both on the employer's side and the employee side, is that for the employer, investigate. Investigate before you charge an employee so that you are prepared, and ensure that everything is fair, meaning substantively, the reasons must be fair. Procedurally, it must also be fair. And employers need to ensure that they've got chairpersons that ensure that the process is ran fairly. Because in the event that it is not fair, it can be very costly for the employer when that matter goes to the CCMA. And for the employees, abasebenzi bethu sithi nawe msebenzi, prepare yourself sufficiently and understand whether you have a case or not. If you have a case and you feel strongly about it, prepare your witnesses, prepare yourself as well, so that you stand a better chance of defending yourself in an inquiry. Chairpersons, of course, have a duty to ensure that the process is fair for both parties. It is in the best interest of the chairperson to do so, and of course, especially in the best interest of both the employers, the employer's representative, and the employee concerned, because we don't know. The relationship could still continue after that process. So it has to be fair. That's all from me, Jonathan. Yeah.
Thank you very much, Osgwazi. Motomonta, that was Gwazi Dlamini from Nel Mondi Consulting. They are with us every Thursday. Rubisanaga the issues are labor, the issues are HR. Remember, if you want to be part of this community, subscribe to our channel, support us. Let's build this community. We want as many people to reach to get this information everyone on weekly basis. Or you can send us an email at podcast@calabashcomnetwork.co.za. Podcast at calabashcommunitynetwork.co.za. As WhatsApp us on 081 5813936, 081 5813936. That's where you must contact Rona on weekly basis. Oskwazi, next week we will be talking
Yes.
again
We'll be talking about the grievance process.
the
Yes,
grievance
definitely.
process. Okay,
Yes.
thank you very much, Oskwazi, and everyone else. Till next time.
Thank you.
Thanks for watching. please share your comment and like this video. Help us grow our community by pressing the subscribe button and grow with us.